Thank you, Mr. Chair, and thanks to the panel for being here. The conversation is of great interest to me. I'm from Oregon. The remarks regarding allowing the states to have more to say about process are of concern to me because in Oregon, that means more delay, more litigation, more judicial activism, not less. And so I'm curious about the suggestions that are, and your thoughts on the suggestions contained in HR 4776, Section 113, Judicial Review. And as an attorney, I understand delay. I understand litigation. I engaged in a lot of it, and I'm just curious as to your opinions. I'm going to start, I think, on this end, Mr. Harrell, your thoughts as to Section 113, Judicial Review, and what I'm most interested in is the focus on the word procedural as opposed to perhaps substantive challenges, because as you can tell when you read this paragraph, it's all about procedure, not about something else. Your thoughts about that focus on procedure?
Yeah, and that's the crux of NEPA. NEPA is a procedural law, and so absolutely litigation should move forward and be available if the process that is required under NEPA isn't conducted, right? And if there are we've gotten gravely off track. But far too often now, this litigation has spiraled into issues that are not in the scope of NEPA, into scope of other environmental laws, or into the scope that are not specific to an individual project or within the realm of foreseeable impacts.
Do you find it interesting that the way it reads, it says, notwithstanding Chapter 7, so forth and so on, in reviewing a claim of whether a final agency action complies with the procedural requirements of the Act. Do you view that as an attempt to limit the scope of the review to procedure as opposed to something else? Because I do, and I'm just, we're doing this for purposes.
Yes, it should be limited to the procedural violations under NEPA, if there is one.
If you would go further into line 5 and 6, it says, if the court determines the agency abused its substantial discretion, tell me what that means, substantial discretion as opposed to what type of discretion?
Yeah, I think what we're trying to get at is if they go far beyond the scope of which the agency has jurisdiction over.
I would review it as, I would think it's more restrictive than that, but that's my thought. If you go a little bit further, it says the role of a court in reviewing a claim described in subsection A may not substitute its judgment for that of the agency regarding, quote, the environmental effects of a proposed agency action. How is that procedural? I'm curious.
Yeah, I mean, that gets to the crux of the 7-county ruling here, right? That effectively, that far too often the judicial entities are stepping in and making judgment calls about responsibilities that are at the agency of jurisdiction, right? So in the case of, in that particular case, critiquing whether how the agency did its environmental review and the scope of it, though they're the ones who are supposed to be making those policy judgments.
Yeah, and the idea, of course, with this statute is to somehow narrow an activist judge and restrict that person from making judgments that take the place of the agency and so forth. It says there's a further part here on restricting what happens when the court remands the matter back to the agency.
Yep.
Your thoughts on that? Because what you see some time frames in here, you think it's actually going to stick? Think it's going to work? You think those federal judges are going to pay attention to our attempt here to limit what they can do in an order?
I think that's why congressional action is necessary. I think both from the 2008 public citizens ruling and 7 counties, you're seeing the Supreme Court express extreme frustration that you continue to see the courts step in ways that they feel like they've already acted on. And so I think the solution to ensure and provide that direct direction is to put it in statute, like the policy put forth in Mr. Wester and Mr. Gold's
I'm extremely happy to see it. I'm almost out of time, so I will mention that, going back to states for a moment, in Oregon we see an attempt to use mitigation as extortion, and it's sad that we don't have more in here that would limit the use by states, the abuse, if you will, of Section 404, because this is another one of those things that unduly delays projects. Thank you, Mr. Chair. I yield back.